Hello everyone, welcome to Redbus US channel. Today, US Department of State has announced new exceptions regarding the US travel entry ban and visa stamping ban for H1B and L1 visa holders, including others. So in this video, we will cover all of these details. So what we look at is what are the new exceptions and the new criteria and how it applies to each of the visa holders H1B, L1A, L1B, H4, and also what is the new process. So firstly, this is the announcement that came in today. So if you look, the updated date is 12th. It's not really like a new announcement. They have updated, the previous guidance more or less, and that's this is what they've given. It's a pretty lengthy one. So in interest of our audience, we'll only cover H1B, H4, L1, L2 related only. We will not look at J1 and H2B aspects. So as you can see on the other side, recently, there have been some lawsuits, and also tech companies like Amazon and all, Amazon, Apple, Facebook, have also submitted something called, amicus brief, which basically supports a lawsuit, in a typical or a giving a opinion as a third party person. So they've actually, mentioned all of these, and I'm assuming all of these things have added up, and that's what has provoked or made this change. Now, firstly, if all the previous exceptions that were there are still valid, so if you were in US on June 24th or had a valid visa for H1 or L1, then if you fall under national test category such as anything related to COVID or research or US defense, any of that, right? It still holds good, so nothing has changed on that front. So the new thing that got added today, or the new criteria, is if you are a H1B visa holder currently working in the US and you want to go back to the US to resume your ongoing employment, then you could, get visa stamping and go to US. So the biggest requirement for that is you need to be working for the same employer when you go back, and you need to work on the same visa type and the same job duty. Nothing of these should change. So usually this is relevant for somebody who has applied for an H1B extension. And you can see this in I-129 form, as you can see on the screen. You have to select option B basically, and in part 2 that tells that this was basically an extension application. So this is the first one. Now, they have actually outlined a set of criteria, about 5 criteria, and what they say is the H1B holder need to meet at least 2 of these criteria. So the first one is, they need to establish there is a still need for H1B holder, and remote working is not possible. So what it means is, because there is a lot of, US workers not having job, they want to make sure even after COVID there is requirement for that. So that's why an LCA is a good indicator of that. So if the requirement is the H1B holder LCA should be approved during July or after July 2020. If it is before, then it's actually consular officer discretion, if it's really critical or not. And also, the work cannot be done remotely outside of US. So if it's eligible to be done outside of US, for example, an IT support job which doesn't require you to be there in person, and you can do remotely logging in or doing VPN, whatever, right? Then it is not eligible. So you need to be really, this third part is important as well. So the second criteria is, you are working as H1B holder for critical infrastructure sector, and there is a real need for it. So basically, what they say is, if you fall under something called the critical infrastructure sector, these are the sectors basically that are chemical, communications, dams, and all of this, right? I mean, you can read the list, right? So if your job duties are in one of these sectors, and if you fall and if you're doing critical work, meeting 2 of the requirements, right? So one of them is you need to be a senior resource in the company, and your job duties must be unique, and there should be needed for the management for the success of company. And the second one is they're either really specialized and they make special, significant contributions to the company in the critical fields only. So these two, either of these have to be met, to be able to qualify for the second criteria. Now, the third criteria that they put is the wage level is at least 15% more than the prevailing wage. As you know, when you file H1B LCA, you actually have a concept of a wage that an H1B holder has to be paid, and there is a prevailing wage also that is available there. I mean, we have a detailed article on this. I'll put a link in the description. You can read that. But the idea is, your wage should be 15% more than the prevailing wage, and for that you need to check the LCA Part F, question 10 and 11. So this is how it look. For example, the one in the screenshot is from a website called H1B Grader. So where you can see the wage that was paid was 181K, and while the prevailing wage is 117K. So you can actually review that on H1B Grader website. They have an interface for searching for LCAs, or even you can browse by the company and look at all the LCAs. So you could actually check and verify that. So the fourth criteria is you should have unusual education, training, or experience. Well, I mean, what they mean by unusual experience or education is, either you have a doctorate or a professional degree, or you have several years of work experience. That's what they mean. And your work should be critical to the company. So again, professional degree is not like a normal an academic degree. I mean, it is slightly subjective, I would say. The expectation is you are actually a professional in a certain area, and you have some practical training work as well as part of that. So that's what is a professional degree. Um, yeah. Now the criteria number 5 is a financial hardship, right, for U.S. employer. So what it tells is if at all the H1B holder cannot come to the US and work, then there will be financial hardship to the company. So financial hardship is nothing but an example where there will be loss for the company and they cannot fulfill a contractual obligation. For example, let's say there is a defense contract or a state government contract, and you need to be in the US soil to work, or they cannot give you to take your work outside of US, all sorts of contracts, right? And you are a critical resource, and if you do not go and work there, then they may lose the contract, or any kind of financial loss can happen. So any of these situations are considered as financial hardship, and of course your employer has to support all of this. So out of all of these 5 criteria, you need to meet at least 2 of the criteria to be able to eligible for getting this visa stamping, and for you to get this national interest exception for this. Yeah. Now that's about H1B holder. Now let's look at L1A. L1A is basically for international executives and managers. So in he similar to H1B. So you should be resuming your ongoing employment on L1A. What it means is, let's say you're working for a company on L1A and you came to your home country for just visiting family, and you got stuck because you didn't have visa stamping. Now you have to go back to the same company in the same role and the same visa category. Then you could actually go and get stamping and go back. So the second one is your work has to be critical business need, and it has to be fall in the critical infrastructure sector. So what this means, it's similar to the H1B criteria that we had in two, the list of the criteria, critical infrastructure sectors. And besides that, critical infrastructure sector, you also need to meet 2 criteria, 2 of the below 3 criteria, right? So the first one is you need to be a senior executive or in a management position, or you should have spent multiple years with the company in offsite, in the overseas office, not in the US. And for the company to retrain somebody in the same company and replace you, it should cost them a lot of money, or I mean, I would say it should be difficult, or it will be loss for the company, not exactly a lot of money. It should be financial hardship, they call it. It should be difficult for them, and they'll lose something, right? That's what they mean. And the third one is it should meet the critical business need part, right? In this critical infrastructure sectors. So again, this is very, very important. They keep coming back to this critical infrastructure, and they're given the list. So you need to be part of that sectors. And also, if you're setting up a new office as H1 L1A holder, then besides these about 2, you also need to employ at least 5 or more US workers directly and indirectly. So that is a requirement. Yeah. So this is for L1A. Now for L1B, it's pretty much same, but it's slightly different in terms of the way classification, right? So again, here also you need to be resuming your ongoing employment similar to L1A, same company, same role. And the second one is because L1B is more for specialized technical expert kind of a role. Here they look at the technical expertise rather than the management or the executive aspects, right? And you need to meet all the 3, right? So the first one is you need to be your job duties has to be specialized, and they should provide significant value, and they should be in the critical infrastructure side or critical those sectors and whatever, right? And also you should have worked for multiple years in that company, and also it will be difficult, or it will be financial hardship for the company to train somebody's I mean, to train another employee, in the same company, right? Within a short amount of time, whatever you can call it. Yeah. So those is about L1B. Now looking at H4 and L2, so as long as the basic rule of thumb is, as long as the H1B or L1 holder qualifies for any of these national interest exceptions, things, then the H4 or L4, L2 holders can apply for US visa and come back. So this is including the ones we had in the past, right? Yeah. So now the process to get a US visa is slightly different now. The reason is still most of the consulates are closed for regular operations. So you can't really directly go and book an appointment. So there is a two-step process. I mean, and of course, they say that you should always look at the US consulate in your country to get those details. So the first step is you need to raise an emergency appointment request with them, attaching all the documentation and proof. And based on that, they would qualify if you would fit that or not, and they will give an interview slot for that if you're eligible for it. So after that, then US consular officer will actually determine if you actually qualify for the national interest exception or not. Yeah. So this is very, very important. You should not be trying to really trying to do I mean trying to do anything that is not really legal, something that's not right. Try to create any fraudulent documents, because at the end of the day, US consular officer will determine and they will look at it. So you should never try to create anything that is not true. So be careful on this. And again, ultimately, until you get the US consular officer making sure that this is a critical and you fall under this national interest exception, you will not be able to get it. Yeah. So this is the complete details on the process with the new exceptions. So again, hope you got a good idea of what came today. Hopefully, this will solve a lot of issues for families that are separated, and some of you can return to US. So thank you for watching, and do subscribe for getting regular updates.